You're Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Marc and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651 645 2922 or visit www.milburn.com. Welcome back to You're Free to Go. Thanks for joining us today. We are recording this episode just a couple days after the P. Diddy sentencing, which was a pretty controversial sentence. And we just kind of briefly will address that. You heard in the news that the judge gave him 4 years. Now, he's been in
Actually, 50 months, 4 years and 2 months.
That's right, a little bit over 4 years. And
every day counts when you're inside.
Every second, I think, counts. Even when we go visit, I'm like, well, I was only there for an hour, but it seems like a year.
Seemed like a year,
It's horrible. So what's interesting, of course, is that he's been in 14 months, so he gets credit for all that time. And, the estimates are that he'll be out within 3 years with gain time, possibly good behavior, other reductions, maybe moving to a halfway house and so forth. He could be out in a lot less than 3 years.
I think he'll be out much sooner than that because you're typically eligible for an 85% service of your sentence.
Right, 15% discount.
Right, 15 for good behavior, which basically means you don't do something really bad inside.
Right. Yep.
You don't have to do anything exceptional either.
Right.
And just about everybody gets that. There are certain types of crimes that may or may not be eligible for that, but not in his case.
Sure.
He wasn't convicted of any child pornography charges or anything like that.
Right.
So it's possible that if he gets the gain time, which is 85% of 50,
right,
which is 42 and a half, and you take 14 off of that,
right,
what does that render? That renders, what, 28?
I think 28 months.
And a half.
Right.
Months. And then there's this thing called halfway house.
Yes.
You could potentially be, there's no way of knowing, eligible for up to 6 months of halfway house.
Right.
So it's quite possible at the end of the day, he could wind up spending less than 2 years in federal prison.
And if our listeners go back and listen to our earlier episodes where we talked about this, that's exactly what we predicted. That's exactly what we predicted would be the outcome here. Yeah. So the point, though, is he's not free to go.
No, he ain't.
Not free to go for a couple more years. And, he might have gotten even better sentence except for one major faux pas. And I think the judge was really offended by this and probably gave him more time than he had planned on giving him. The prosecutor somehow found out, I don't know how, it's just, I guess they know everything. They're the government, but they represented at the sentencing hearing that P. Diddy had scheduled an in-person speaking event in Miami for a week after the sentencing hearing, which clearly indicates he thought he was going to get probation. His lawyers were asking for probation. He had a great defense team. I'm sure were not aware of this because it caught them off guard. But the prosecutor somehow found out, and you can imagine how upset the judge was about the arrogance that someone would plan an event in person in Miami a week after sentencing.
Right. But I think the driving factor, it's interesting. If he had only been charged with the crime he was convicted of, and the only evidence in the case was that, he probably would have gotten a very light sentence.
True.
Yeah. But the way the government tried the case, which was very interesting because most of us watching from the sidelines, and I have to say up front, the high-profile cases I've been involved in, when I read in the newspaper all these lawyers talking about the case who aren't in the middle of it, I'm always offended because my attitude is you don't call in plays from the bleachers.
Right.
Not even from the sidelines, maybe. You're on the field. But in this particular case, it seemed to many of us while we were watching it, the government was so busy trying this case to point out his violence against women, which it didn't seem directly related to what some of those charges were, which ultimately the jury convicted him of, acquitted him of the main charges. But as it turns out, all that evidence of his violence was one of the main factors the judge mentioned in giving him the 50 months.
Right. And it's why the judge kept him in prison after the verdict.
Right.
When they asked to have him released on bond pending sentencing,
Right.
the defense asked for that. And the judge said, no, there's been evidence that he has violence in his past. And I have, on that alone, I have the right to hold him in the jail. He wound up giving him a prison sentence anyway. So even if he had let him out on bond, he would have had to come back and surrender and finish out his sentence. So interesting, very controversial. A lot of people wanted to see him go away for the 11 years that the government was asking for. Of course, on the defense side, and his fans and supporters were hoping he'd get the probation that his defense wanted. So that I don't think we've heard the end of that case.
I don't know. I don't know what the appeal issues will be, but everybody, all our listeners should know, it's sort of an interesting way of how the criminal justice system works. When you are able to represent somebody before they're even charged in what we call pre-indictment, the opportunities are there to talk the government out of the case, or in situations you work out a very favorable plea. So you're sort of like a little bit uphill, but it's not much. Then when you wind up going to trial, it's more uphill.
Sure.
Okay, the government's decided to indict. They've been investigating the case for a long time, and they're able to put together their best case. And if you're convicted and then you appeal, the opportunity to win then is really uphill.
That's right.
Very few appeals are successful. And sometimes, even if you're successful, all you get is a new trial.
Right, which may not be the best thing.
Right.
You got to be careful what you ask for, right?
You may get it.
You may get it, and then it could turn out even worse.
Well, interesting result in a serious case, and I feel sorry for the victims.
Absolutely.
And it is what it is.
Yep.
So.
And I echo what you mentioned earlier. We've said it before, though, that when people ask us to pontificate on cases that aren't ours, it's really unprofessional. It's not the right thing for us to do, or any lawyer to do, unless it's their case. Unless you're sitting in that courtroom and listening to every single word, you really can't, call balls and strikes from the bleachers.
You can't.
You can't, because one sentence could change your entire opinion of a case, and you just happen to be in the bathroom during that one sentence.
There are nuances involved when you're in the middle of trying a case that you cannot understand, perceive, or imagine sometimes when you're watching it even on TV, or you're even sitting in the courtroom, because you're not privy to conversations that take place privately with the judge and what we call in camera, or you ask for a sidebar.
Sidebar, sure.
And so, but this is our best read of it.
Right.
From our vast experience.
Yeah, and we will talk about cases occasionally that are in the media, but we're going to talk about it more from the legal nuances going on, and try to explain to our audience what certain procedures are about and why they do things the way they do.
Right.
So, but today we'll move into our episode. Instead of talking about crazy-ass cases, I think we decided we're going to talk about probably one of the, if not the most common arrest throughout the United States, which are at the state level, typically DUI, driving under the influence. A lot of people we talk to, when they hear we're a criminal defense lawyer, they ask us questions about DUI. Since we did this podcast, people have been saying, hey, you ever going to talk about DUI? So I think it's a good time for us to spend an episode on it. And, for our listeners, Marc and I have talked. We clearly, unequivocally do not condone drinking and driving. It's just, we want that to be...
A car is a weapon.
It is a lethal weapon.
It's like having a gun in your hand if you're drunk.
Right. And he's not just saying that from his opinion. It's the courts have considered and ruled that a car is a lethal weapon. So if you get behind the wheel while you're impaired, it's a very serious crime.
And the interesting thing is you can be judged legally impaired with just a few drinks, and you may not feel it. You may not realize it.
Right.
You may think that you're perfectly fine to drive, but if you get stopped for whatever reason and you take a breathalyzer test, you could easily fail it.
Yeah.
Which is the best thing that's ever happened for people regarding the opportunity to avoid DUIs is Uber and Lyft.
Yeah, and yet DUI arrests are increasing every year,
Yeah,
which
that's
shocks
strange,
me.
huh?
It really shocks me when the Uber came out. I said, "Boy, what a great solution for drinking and driving." And the reality is, let's forget a serious car accident from DUI. Let's just say a straight DUI, no accident, pulled over for speeding, you get arrested. That's going to cost you like $10,000 and a criminal record. The Uber would have cost you $25 or less.
Not to mention in
Right.
California, where I live and have an office also, it's very strict how they deal with DUIs, and you've got to do all sorts of community service. You've got to go through so many things. It is really a problem in your life. It makes a big dent in your life.
I agree, and I think a lot of people don't understand, if you get DUI, why you really, really, really need a criminal defense lawyer. And one of the reasons, like you just alluded to, there are a lot of restrictions that are statutory, that if you're found guilty or you plead guilty to a DUI, that they're statutorily imposed. The judge must impose them on you. But one that is extremely serious is a conviction. And a lot of people don't realize that if someone is entering a plea to a criminal charge, the judge has discretion in almost all cases to not convict you. People think, oh, if I admit guilt, I'm getting convicted. But there's something in the law that you and I know called a withhold of adjudication.
In Florida.
In Florida.
Yes.
Yeah.
And many states, not all states have that.
Right.
But in Florida for sure.
Yeah, and what it means is that you can you're not a convicted of a misdemeanor or convicted of a crime, whether it's a felony or misdemeanor, and it's a big distinction. In Florida, if you plead guilty or are found guilty of DUI, the judge must convict you. There's a lot of other crimes, where the judge can exercise discretion not to convict you. I know the exceptions are for murder, and which is appropriate, you should be convicted, and fleeing. Police officers, you have to be convicted. The theory there being that you're putting yourself and others, the public and officers, in danger if you're fleeing. So if you're going to flee, you're going to get convicted. But you could, steal bubble gum from a store. You could commit a battery on someone, and the judge can exercise discretion, again, in Florida and a lot of other states, not to convict you. So because you're getting that conviction, because you have a lot of community service, you have to do a alcohol evaluation, you have to go to therapy, you have to do a lot of things. It's very onerous and expensive. You have to pay probation, you have to pay your lawyer, you have to pay fines. And like I said, it can be easily $10,000 when you're all done, besides the fact that you now have a conviction. So I think it's really important that people understand that you have to hire a defense attorney if you get a DUI, because the consequences are just simply that high. And you need to hire a lawyer who has experience with DUI.
Yeah.
I always talk to people about this because I know a lot of criminal defense lawyers who would rather try or defend a bank robbery than a DUI, because the bank robbery is you have witnesses, you have evidence like a fingerprint or a video. DUI can be very much a opinion crime, very subjective, that maybe you get pulled over for speeding, there's one or two cops that are there, and it's there, and let's say you don't give the breath test, which we'll get into. It's very much their opinion that, yeah, you were swaying, your speech was slurred, and it's hard for a defense attorney to defend an opinion crime. It's easier for them to defend a crime where there's, like I said, like a bank robbery. So you really have to have a lot of experience when you with DUI defense to be a good criminal.
Definitely, and I have to interject at this moment because it leads to a funny story. I'm not a DUI expert. In fact, I don't do DUI, as you know.
Yeah, you send them all to me.
All of my cases, almost all my cases, are in federal court. But many years ago, if you remember, Florida is a very unique state. I think it's one of only 2 states, or maybe there are just a handful more, that allow for depositions in criminal cases.
Right.
In the federal system, no, and in most other states, when you get charged with a crime, there's just so much discovery or opportunity you have to challenge it before trial. In Florida, you get the right to take depositions of witnesses that the state lists as witnesses that they're going to call at trial. Now, it used to be that applied to misdemeanors and felonies, both. And then at some point, the law changed. Because I never did misdemeanor cases,
Right.
I didn't pay attention to that change. And one day I get a call, and I didn't know it had changed.
Right.
It's only for felonies now. I get a call from somebody very close to me who begged me to handle his DUI case. And I violated my general principle,
Right.
which is stay in your lane.
Absolutely.
And I did it. Actually, what's even worse is I didn't get paid a fee. I did it as a favor.
Wow. Okay.
And I read up about it. I learned as much as I could about breathalyzers and the people who operate breathalyzers.
Sure.
And I have my secretary, who obviously didn't know either, send out notices for deposition to the state and subpoenas for the breathalyzer operator,
Right.
for me to take the deposition. And I'm all prepared. I'm ready to go. And of course, the state didn't show up. They didn't respond. And a lot of those misdemeanor cases
Right,
in the past, they don't show up.
Right.
Right.
Which our listeners may think that's weird. Like a defense attorney shows up to take a deposition of someone and the prosecutor doesn't even show up.
Doesn't even show
and
up.
you think, God, that's so lazy. Like,
Yes.
but anyway, that happens a lot.
So what happened is I take this deposition, and I'm on my game. I'm prepared, and I rip apart
Oh, boy.
the breathalyzer evidence through my deposition of the guy who operated it. And now I am so excited that I've blown this case up that I call the prosecutor and I tell the prosecutor, well, I guess you got no case anymore. And he says, what are you talking about? I said, well, I just took the deposition of so-and-so, and this is what he said, blah, 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 and this is what happened. The absolute, that machine is not a valid test.
Oh, my God.
And he goes, what do you mean you took the deposition? He says, it's a misdemeanor. You're not allowed to take
Right.
depositions.
Yep.
I said, what do you mean? He says, yeah, the law is changed.
Right.
You're not allowed to take depositions. He said, you're in a lot of trouble.
Oh,
I go, oh, my God. And he said, more importantly, he said, you can't use what you did.
that's right.
You can't use it. Well, luckily for me, luckily for my client, we resolved it by working out an agreement
Right.
that instead of my client pleading to a DUI, he pled to some reckless driving,
Sure.
which didn't affect him in the same manner at all.
Right.
Got a withheld adjudication.
Right, that was the key
And
that
that
we
was-
just-
So it was a win-win for everybody.
Right.
And for me, it was a lesson well learned.
Right.
Stay in your lane.
Stay in your lane. Yeah, you can you have to get court permission on misdemeanors
Right.
now. You can ask the judge to take, hey judge, I need to take a deposition in this case.
But it's
And
not automatic. I
It's
thought.
not automatic, yeah. But you're right. We always have to stay in our lane. I remember when I passed the bar and I met with a friend's relative who was a 30-year practicing lawyer, and that was their advice to me always. They said, and if you want to do a new area of law,
Associate with somebody.
associate with somebody, yeah, and let them cut your teeth with somebody else that can show you.
That's why we work together on things.
100%.
Yes.
Yeah. So, again, back to like the basic DUI, DUIs, I wrote an article a few years ago. It says DUIs aren't just for alcohol anymore because they're actually for being under the influence of alcohol and or drugs. And they're actually, over the last 15 years or so, there are a lot of police officers who have gone for extra training to become what's called a DRE, drug recognition expert. And before they get that certification, an officer can't testify in court regarding impairment from drugs. But once they become a DRE, they can actually testify to it. So people think, well, I didn't have any alcohol. I'm high on marijuana, and even though that may be legal in your state, you can still be impaired. If it's impairing your ability to drive a car, to do your normal everyday functions, to walk, talk, judge distances, dexterity, things like that. That's what impairment is. That's how they define it in the statute. So it can be drugs or alcohol.
So if you're stoned and you're going 15 miles an hour
Right.
in a 60 zone,
That is DUI.
that's a DUI. It always reminds me of the Cheech and Chong Up in Smoke
Right.
movie, where the car is filled with smoke, and I think Chong turns to Cheech and he says, how we doing? And she says, we're parked.
yeah. I love that. I may go back and watch it tonight. That was hilarious. Yeah. Well, with a DUI, what does the cop have? There's a couple things that they build these cases on. They build their observations of a driving pattern. We reference maybe running a red light, maybe a car accident, maybe, very commonly failing to maintain a lane. So one thing, swerving in and out of your lane. So you have, like I said, you have a couple things make it up. You have a driving pattern. You have the police officer's observations of you. You often have a breath test or the lack of a breath test. And then you have a a Q&A section where they ask you questions, the cop, where were you going, where are you coming from, how much did you have to drink? And then you have the field sobriety task, which everyone knows is walking the line.
That's roadsides.
Yeah,
right?
the roadsides, touching the nose and so forth. So what's interesting about it is when you get pulled over, and again, we're not condoning, we're not encouraging people to drink and drive. And by the way, it's not illegal to drink and drive. You are allowed to drink and drive. You're just not allowed to drink to the extent you become impaired and drive. So if you're someone that can have a half a drink and it does not impair you, you're not breaking the law to drink and drive. But again, we're not condoning that someone get out, drink, or have drugs to the point they're impaired and then drive. But we're just sharing how this all plays out in the court system. If you get pulled over for, let's say you have an accident or you do speed or you fail to maintain a lane, you get pulled over, that the cop has all that information on you, their observations of your driving pattern, and they'll observe you too. But all these other things I just mentioned, the breath and the Q&A and the field sobriety tasks or roadsides, those are, if you perform those or cooperate with that, you're giving evidence that can be used against you. So the idea is, you have the legal right to refuse.
But there is a consequence, though, isn't there?
Well, the couple consequences. One is the government can argue that the refusal is indicative or indicia of guilt. They can definitely say that. They can also, if you refuse the breath test, in most states, the first time is not a crime, but if you refuse a breath in a second stop, then that can be a crime. So a second refusal becomes its own criminal offense.
Now, I had heard, because this is not my area of expertise, so correct me if I'm wrong, that in many states, I think this may be even true in Florida, if you refuse the breathalyzer, you automatically lose your privilege to drive.
Yeah, it's really, really frustrating because I'm telling you, 100% of the DUIs I've defended, and as a prosecutor, excuse me, and then defense attorney, I've easily handled 3,000 to 5,000 DUIs. As a prosecutor, probably 1,200, from 1992 to 96, and then since 96 in criminal defense practice, 2,000, 3,000, like a lot of DUIs, right? And every single defendant says that to me. The cop told me my license would be suspended, and that's why I took the breath test. It's a misstatement of the law, and the courts have allowed cops to misstate the law. What they fail to tell you is that you are eligible for a hardship license. If you refuse that breath test, you can, within 10 days of the arrest, go to the Department of Motor Vehicles and ask for a hardship license. That hardship license allows you to drive for anything related to work. So if your boss says, hey, can you run to Office Depot and get us some paper for the printer, you can do that. Or if you're in sales and you're going to meet someone for lunch to try to solicit business from them, anything related to your livelihood. To and from any religious affiliation, your church, your temple, if you go to a Bible study, to and from any medical care, to and from any education. So if you're taking adult education classes.
Or if you're in school.
Yep, if you're in school. And then, I think I say medical care, education. Yes. Oh, to and from the grocery. We have to eat, right? So you can't drive and go to some restaurant and drive home, but you're allowed to go to and from the grocery. So the police don't tell you that. And if they did tell you, I guarantee you a lot of people would refuse the breath test.
Because without the breath test, which is scientific evidence, which is harder to challenge, you have the cop's personal opinion.
Correct.
And their view. Now, don't they tape these things, though?
Yeah, so that's the biggest. The cops hate these body cams that came out, about 8 years ago now, 10 years ago? And we've seen in other situations where there have been, suspects have been actually died at the hands of officers.
No, I think the body cams overall is a good thing.
Right. A lot of police really don't like them.
Right.
And they don't like them in DUIs a lot because we as the defense will say the best evidence is the video. So we'll say to the jury, look at this video, listen. It's not just video, it's audio too. And listen, the police officer testified and they wrote in their police report, slurred speech, bloodshot eyes. You're going to zoom in on this video. You're not going to see bloodshot eyes. You're not going to hear slurred speech. They're going to tell you that they were swaying, 4-degree sway to the right and left. Look for yourself. That's the best evidence. So the officers...
I can't walk a straight line with my bad knee.
That's true too. Which, by the way, when I do these DUIs, I always tell a jury in closing argument when they go in to deliberate, try to do these field sobriety tasks. Even it's with a bad knee. You're think about yourself being nervous. The cops are there. There's usually 3 or 4 or 5 cops show
Right.
up on scene. A lot of cars are passing you. It could be late at night. You're not on,
Tired.
you're
yeah.
tired, right? You're maybe not on a flat or level ground. Maybe it's gravel. Maybe you're in some high heels and they don't offer you to take them off. There's a lot of factors. You're nervous. You realize if I don't do well on these, I'm getting arrested, right? So we often encourage jurors to go try it, and see how you feel about it. So I usually find when I interview jurors afterwards, they say we disregarded everything we heard about the field sobriety task. One of the things cops do that they don't tell when they instruct someone before each task how to do it, right? Walk heel to toe 10 steps, do a 360-degree turn and walk back heel to toe 10 steps. Well, when I have the officer perform it in the courtroom, I notice they do a trick to make sure they don't fall off the line. They take their hands and they put them in their pockets and they push down very hard with their pockets by their thumb. And what that does for them is it gives them a stronger sense of gravity on the ground so they don't lose their balance. And I'll always point out to them, well, you didn't tell my client to do that, did you? You just did that in front of the jury to show how perfect you can do it, but you didn't tell them. So when the jury hears all of that and they see all the tricks that the cops pull when it comes to the field sobriety tasks, they typically disregard those tests or tasks, the roadsides. They say touch the tip of your finger to the tip of your nose, and if you're a fraction of an inch off, the cop says, oh, they missed. They just simply say, oh, they missed the tip of the finger to the tip of the nose. And I'll say, watch the video. You'll see you didn't miss. So prosecutor, police put a lot of weight on those field sobriety tasks. Jurors at the end of the day usually don't.
So basically what you're saying is, as a defense attorney, it gives you great opportunity to challenge the state's case if it's based on roadsides, on
A driving
observations, all that.
Yeah.
But what happens when your client, let's say it's most states, it's 0.08%
Right.
alcohol content in your blood. What happens when your client has a 0.15 alcohol content
Right.
in your blood?
So which is most people, a lot of people do give a breath test, and you just referred to the word blood, and the truth is the statute says blood alcohol content, and so a lot of times people will ask me, well, I blew in a machine. How does that turn into blood alcohol? Well, it's a very, very sophisticated, as the experts call it, an instrument, not a machine, a medical instrument. And it does convert. You have to blow for a very long time and at a certain amount of pressure. Actually, some elderly people or people with different types of medical illnesses can't actually blow hard enough or blow long enough. But the idea is that if you blow properly into the instrument, it's getting your deep lung air, and there's some type of mechanism within this instrument that converts that air into a blood alcohol reading.
Based on what, the blood volume that it estimates in your
Correct. Body, yes, correct.
So what happens if let's say I'm 170 pounds, and then you've got another person who's 270 pounds.
Right. Everyone metabolizes alcohol differently. Body weight affects it, how much you've had to eat, race, sex, there's a lot of different aspects of it that affect it. And by the way, if you are a true alcoholic and there's someone who drinks all day long, again, you mentioned 0.08 is the legal limit. Let's say you could blow 0.35, 0.40, which is getting close to being dead. It means 40% of your blood is alcohol.
Ooh.
If you're a true alcoholic, you can drive. You can look as sober as someone who's never tasted alcohol in their life, because they get used to it. They get desensitized to it, because this is how they live their life, being at a 0.40 all the time. In fact, as a prosecutor, I'll just segue for a second. When I was prosecuting, they did a DUI conference that they took me to in Orlando, and the Florida Highway Patrol came and they set up some instruments there for us to blow in the machine, and they had alcohol that we could drink and blow in the instrument and so forth. And then they brought a couple people. They said, oh, we found some people from the community that volunteered, and they did the field sobriety tasks in front of us, and they asked us as prosecutors, I think there were about 40 of us there, would you prosecute any of these individuals? I think there were 4 people. It was going back to 1992, so it's been a while. And none of us raised our hand. None of us would have prosecuted them because they all did the field sobriety task flawlessly, better than you and I would have done it. Really perfect. And they said, okay, I think that's, you guys are very observant. They said, all right, now let's just see, if they all blow 0.00, it'll make sense. The first one blew 0.31.
Jeez.
The second one was like 0.27. They were all like 3 times the legal limit. And then the Florida Highway Patrol told us that these 4 people, I think it was, are known homeless alcoholics in the community. And they work, they bring them to these seminars all the time to make the point that for us as prosecutors, that don't be fooled by someone's performance on the field sobriety tasks, because if you're an alcoholic, you're going to be able to perform them well. Now, I've had a lot of young kids drink, and they tell me, guys, the first time I've ever had a drink, I had 1 drink, 1 1/4, and I drove, and they were wasted, right? Because they hadn't built up a tolerance. You go to college, kids build up a tolerance, right? Because they start drinking a lot more. So it's a really interesting crime, and it gets back to, you started something a little earlier when we started talking about how, when you drink, you're kind of relaxed. I talk as much as I can to young people, and I say, alcohol impairs your judgment. That's the bottom line. It impairs your judgment. So when you start drinking, you're going to feel like you're fine. You're going to feel like you can drive a car. You're going to feel relaxed. You're going to feel at ease. Excuse me. And you're going to drive, and it's going to turn out that you were actually impaired, drunk, and could kill somebody. And that's the effect alcohol has on you. And therefore, I tell all young people, if you have a sip of alcohol, you do not drive. It's that simple. You have to have a black and white rule that if you taste any alcohol, that you are not driving. I mean, I'm a realist that people under 21 are going to drink alcohol. They're going to sneak it from their parents' house or whatever. So I tell them very clearly that has to be their black and white rule. And, I hopefully have impacted some kids because, as you know, God forbid, you drive and kill somebody, your life, you're going to prison. And what's amazing about DUIs is almost 90%, I've read the statistic, almost 90% of the time when there's a DUI fatality, the DUI driver survives. And they say the reason...
Why is that?
They say because you're so relaxed. The person who's driving, who's not impaired, they see an accident coming, they stiffen up, and their arms get really stiff, and they become rigid, and for whatever reason, that causes more injury to a person. But when someone's under the influence of alcohol or drugs, their body is more limp, more relaxed, and they kind of go with the punch and go with the flow of the accident. And
you're saying, generally speaking, they suffer less injury?
Correct. And they wind up surviving very, 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 like I said, the stat I read, it's been a few years now, was 90%.
Wow.
Yeah. I had a case once where my young person in college age was driving, DUI accident. Their best friend was in the passenger seat. And when they got out of the car, they moved their best friend, who was dead, into the driver's seat. And then they said they were the passenger.
They're really, in this day and age, there's no excuse for it, because you've got Uber, you've got Lyft. Maybe there's somebody in your group of people who is sober, who isn't drinking. I mean, it really is inexcusable to put yourself in a position. It's not only do you potentially harm other people,
Right.
You can create property damage, which is always a problem, but you harm yourself.
Right.
And it's just, I'm, shocked that people still get into a situation where they're blowing a 0.15 or a 0.2 or 0.3.
It is.
And you just wonder, was there anybody there who was in a position to supervise them and say, hey, you're not driving, I'll drive you home.
Right.
Take an Uber, leave the car.
Yeah. There's one of the things, the consequences that we didn't talk about with probation and the convictions. One of the things when you're is a interlock device, it's called, where it's a mechanism that goes onto the steering column of your car that you have to blow in. It has to detect no alcohol, and then the engine turns on.
But that's only for people who have already been convicted.
Right. But I want to get to your point, though, is that what was happening, and this is so asinine, was that when the first generation of this interlock came out, let's say you and I are out together.
Oh, another person would blow.
You're sober,
Right.
I'm drunk, and you're like, oh, you're fine to drive. You would blow in it for me. The car would start, and I would drive home and cause an accident and get DUI. So the second generation of the interlock has what's called a rolling start. About every 30 seconds or so, you have to blow in it, or else it's going to turn off. But the first generation friends who were sober were blowing in it.
So
It's
let me ask you
unbelievable.
this, as a practical matter, is the technology available that everybody who goes to a bar or whatever could have a very simple device? Let's say someday it's on your phone, or, with all the latest inventions, and you can just check yourself.
Right.
Did I drink enough that my judgment is impaired?
Yeah.
If you had 2 drinks, maybe I should check.
I never understood why those haven't taken off in my whole life. I've seen a half a dozen bars that actually had something where you could blow in. I've seen online where you can buy a little mechanism. And I wonder, as lawyers, there's civil liability. Maybe someone blows at a bar as they leave. It says they're fine. They go, they get arrested, they cause an accident, DUI. Do they then turn around and sue the bar and say, hey, I took it at your bar and it said I was .02?
Damn lawyers.
Right, lawyers are, but it really would be a nice solution for people. But then again, what would happen is someone would blow and it'd be a .09 or .10, and they'd say, oh, I'm fine though. I know I'm a little bit over, but I feel good because remember, it impairs your judgment, and they drive anyway probably.
So what about forgetting alcohol for a second? Let's switch over to drugs.
Wait, before you guys go to
Oh,
drugs,
question
sorry.
from the peanut
Well,
gallery.
I just gotta say, we got sponsors now, so let me run an ad.
You are right. We forgot our sponsors. We wouldn't be here without them. So go ahead, Ben. Thank you.
My pleasure.
You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427.
Yeah, so when we took our break, right before that, I asked you, well, what about in the situation where someone is ingesting some form of drug, whether it be marijuana, opioids, whatever?
Yeah. So they were prosecuting those now. The DREs, the drug recognition experts, are prosecuting those. They're harder to prove because under most states, you can't draw blood without someone giving you permission. If there's a serious bodily injury or fatality, most states allow compulsory blood. Meaning
So
you can
if you commit, if you cause an accident and there's suspicion, reason to believe that you were high,
Right.
and you're in the hospital, let's say, you're injured too, they can take blood.
Right. So there's 2 types of blood. There's legal blood, which is where someone consents, the driver consents, yes, you can draw my blood, or they can take it without consenting. Legal blood can be taken without consent if there's an accident with serious bodily injury or death.
Well, what if
And
they're
then there's
just
what's
drawing the
called-
blood as part of your
Right.
medical
Then that's called
treatment?
medical blood. And yeah, it's for the purposes of treating a patient that was brought to the hospital. The prosecutor, the police, they don't get to see that because it's part of the patient, the HIPAA rules and the doctor-patient privilege.
Right.
So what happens is the officer will tell the prosecutor, hey, when I took him to the hospital, they drew blood. The prosecutor will then file a motion in court to subpoena that blood. And I've seen that motion, 1,000 times, and 1,000 times the judge has signed off on the subpoena granting the violation of HIPAA, and they do get.
They have the power to do that.
And they get that medical blood, and it comes into the evidence. So it does hurt. And with the other drugs, if you're not getting a blood test and it doesn't show up in a breath test, the DRE officers are testifying to bloodshot eyes, maybe sweating, other things that they've learned through their training and experience that indicates influence of an opioid.
That's harder to prove.
Very hard to prove. Very hard to prove. So what I've found though is if someone asks you to get out of a car, if the officer approaches you and they say, we'd like you to step out of the car, I'll take depositions of those officers. And one of my questions always is, how many times have you pulled a car over, for that wound up being a DUI or something? They'll say, I pulled over 1,000 cars. Well, how many times did you ask that person to get out of the car? And they'll say, 1,002. So I said, out of 1,002 people that you pulled over suspecting them of DUI and got them out of the car, 1,000 of them you arrested for DUI. So in other words, the moment they ask you out of the car, they've already made their decision. You're going to the pokey for DUI. So you do have to get out of the car because you have to comply with an officer. But at that point, you don't want to give them more evidence against yourself. At that point, all they have is their observations of you and your driving pattern. So you don't want to give them a breath test. So let's talk about breath again for a minute. So I actually drew a diagram here that I want to show anyone that's actually watching this, but I'll explain it as well. This is called retrograde extrapolation. And what you see when someone starts drinking, before they take their first sip of alcohol, their blood is 0, right? Has no alcohol in it. You take your first drink, your blood starts to absorb the alcohol. So it goes from 0 to 0.01. You have another drink, goes to 0.02, 0.3, and it's absorbing and it's going up, 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 up. At some point you stop drinking. Let's say you get to a 0.2, you've had enough to drink. It stops at 0.2, and then you go through what's called elimination, where you now start going down, 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 down. So you got as high as 0.20, and then you went down to 0.19, 0.18, and it's about a 2 to 8 hour period where you'll get back down to 0.00. So you absorb from 0 all the way up to your highest point, and then you eliminate all the way down, getting back to 0. And what retrograde extrapolation is people don't get tested for their breath at the scene. Very rarely. If there's a roadblock where the cops show up with a bunch of cops and a bunch of intoxilizers and they're pulling everyone over, but that's very rare. Usually you get stopped for speeding, running a light, causing an accident. There's a whole hour on scene of investigative work. They take you to the police department. So it could be 2 to 3 hours later that you're tested. Well, when you test, you might come out at, if you look at my diagram here, at 0.05, because you haven't had a drink in 2.5, 3 hours. So you're in the elimination phase of that alcohol experience.
Which means you don't get charged?
No, I wish. It means that they're going to the prosecutor brings an expert toxicologist into the case who's going to retrograde and extrapolate back in time 2.5 hours and go on this little graph. If anyone's looking versus listening to the episode, they're going to go back up the elimination and then back down to your absorption. And they're going to say, based on your weight, your height, your race, your sex, what you told the officer you had to eat that night, that 2.5 hours earlier, you were actually at, 0.19 or 0.15.
Well, that's an estimate based on their
yeah,
opinion,
and
expert opinion.
Right.
But
So-
it varies, doesn't it?
It does, but they're an expert witness, so they're allowed to testify that in their expert opinion, 2.5 hours earlier, you would have been at 0.12, and the law is 0.08, right? So people think, well, I haven't, if I'm, like you just said, hey, if when you finally take the test, you're below 0.08, they're not going to charge you. But the prosecutor will retrograde, extrapolate it back to the time. The law says at the time of driving. All right, so what were you at the time of driving? So that's how that goes back.
So are there other factors as a defense attorney you can bring up on cross-examination of that expert witness that might affect the rate of change?
Yeah, but it gets it gets scientific, it gets medical, and a lot of times you'll lose a jury with that type of discussion. I think what you mentioned earlier is really the most effective after doing as many DUIs as I have. It's challenging the intoxilizer. These intoxilizers have very strict rules about their maintenance. They literally have to be maintained on a daily, weekly.
That's what I challenged back then.
Yeah, and you obviously studied it well enough because if you know what you're doing, you can really beat up on it, because if it's not properly tested daily, weekly, monthly, and annually, then you can possibly get it thrown out. So the test has to be done by a person who's certified. Sometimes their certification is expired. I've had that happen. they're putting special reagents into the machine, like a known liquid that is 0.05, and the result has to come out 0.05 within 0.000 of a percentage, so it has to be accurate. Sometimes you look at the reports and you see, well, they put in the 0.05 and it came out 0.09, so it's clearly not working. So that's one way to really, and then there's arguments you make to a jury, like, they'll tell you that, the intoxilizer was, costs $100,000 to make. And you make arguments like, well, the space shuttle was, $3 billion and it blew up, right? So how do we know this is working properly too? And you say, well, this guy was really 0.10, but look at the video. He looks totally sober. So something's not right here.
Well, it's a very interesting area of law, and you started off by saying something that is very true. Probably the majority of cases out there are DUIs. I know I got called for jury duty in California, and it was announced that it was going to be a DUI case. Nobody picked me because when they heard my background, the fact that I taught trial advocacy and had been a prosecuting defense attorney, they all hated me. They wanted me off.
Yeah. Yeah. I do like going through that process, though, just so you know, when we go to pick a jury, what they're going through, what they're thinking and stuff. But one thing I want you to talk about, because I know you have really strong feelings about pleading the fifth, the right to remain silent. I referenced the Q&A portion of a DUI arrest, right? Cops are looking for you to say things that aren't making sense. Cops are looking for you to say, I'm heading to Miami when you're actually, which would be south, but you're actually driving north. So they're looking for the slurred speech and so forth. But, you always use a great comment about, when Warren Buffett gets subpoenaed to talk, he doesn't show up on his own, right?
Right.
So cops never question if you say, I'm not speaking to you, because when they're under investigation, they ask for a lawyer too.
Right. So you cooperate, but you don't speak.
Right. And you can't get prosecuted for not speaking.
Right, and in fact, in criminal cases, everybody should know this, it's a universal rule. Your failure to speak and answer questions cannot be used against you. If you invoke your Fifth Amendment privilege not to testify against yourself, it cannot be mentioned in court.
Right.
And that's a big difference, because in civil cases, it's different. But your Fifth Amendment privilege is still one of the strongest privileges out there. And that's why it makes sense. I think I mentioned this a long time ago during one of our podcasts. I used to have the big bass, that was stuffed in my wall, and it had a hook in its mouth with the head turned out, away from the mounting, and the bottom brass piece had etched on it. If only I had kept my mouth shut, I wouldn't be in this situation.
That's very apropos for our talk. I agree. Yes. We'll have other discussions about DUI, because it's a complex area of law.
Yes.
And it's a common arrest, as we said, unfortunately. They're super serious. One point I want to share with people is a lot of DUIs, a big percentage of DUIs occur within like a mile of your home, because not only are you impaired, but you're also more relaxed when you get close to your house, because you've driven that street a billion times. You can do it with your eyes closed.
That's an interesting fact I didn't know.
Very often I've had clients say, I was literally pulling in my driveway. Like there's something about, because you cut the curve a little tighter because you know it so well.
Or they've been following you for a while.
Yeah, they do. And that's something that we bring up in defense all the time is, hey, if he was really impaired, why did you drive behind him for 4 miles before you pulled him over? Which is a whole nother legal defense. But
this has been fascinating, Guy, but I think we're
about out of time.
So, ladies and gentlemen, until our next episode, you're free to go.
Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Marc and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Marc Nurik and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.